Well, hello. Uh, we are now on to topic number 5, which is about amending the governing documents. Now, this is an important section to know about because this is a common task that association lawyers get involved with. There are a lot of associations that want to amend their governing documents, which could be the declaration or the bylaws or operating rules, for a variety of reasons. So we're going to talk about um, some of the most common amendment requests and the procedures for for carrying out these amendments. But keep in mind, this is quite a practical session. I believe this is an issue that comes up with some frequency for association lawyers, or just if you either live in an association, you may run across this, or if you have a real estate practice and you run across this issue from time to time. So it's useful to know this. Now, first, amending the declaration or the bylaws, that is particularly the original declaration, the original bylaws that were recorded at the start of the project, can be a challenging process because they always have supermajority requirements that were put in the governing documents for the very reason that the institutions involved in the lending industry have always wanted to protect against the crazy owners, quote unquote, changing the documents and screwing things up. This supermajority policy originated back in the early 1960s. You could find it in old declarations going way, way back, but it became basically standard in the industry because of the Federal Housing Administration when they decided to supply mortgage insurance to condominiums and HOAs back in the early 60s. They decided that they wanted supermajority requirements, typically two-thirds of all owners or all ownership interests. And I interviewed the man who made that decision. His name was Byron Hankey. He was the head of the land planning division of the Federal Housing Administration for decades. And he was a big enthusiast about this type of community. And I interviewed him for my first book, and he told me all about this, why they wanted the protection against too much democracy. And also, you should keep in mind that because the original declaration and the bylaws were recorded against all units at the outset of the project, at the inception of the project, they are presumed, ordinarily, judges presume them to be valid. And they will not invalidate provisions in the original declaration and bylaws unless they are illegal, arbitrary, or contrary to public policy. So one example would be, for example, race restrictive covenants. Those, as you probably know, have been unenforceable since 1948, Shelley versus Kramer. So even if they're in original documents, and you will find those in old documents, they still exist. They're unenforceable, and they can be stricken by judicial action. But remember, they have a presumption of validity. Now, that is original declaration and bylaws provisions are presumed valid unless they are otherwise illegal, arbitrary, or contrary to policy. Now, if you look at one of these old association documents, old declarations, you should review them to see if they contain any time bombs, such as expiration dates, renewal provisions, or restrictive windows for amendment. You find those in some of the early documents, and some of this wasn't thought through very well. Newer documents, you're not going to find this sort of thing very often, but the old ones, pre-1990, you certainly can see things like this. So check them out because those provisions are enforceable, and they may have restrictions on amendment. They may restrict all amendments to a 1-year period every 10 years or something like that. So you need to check this out very carefully. Um, Association operating rules should in general be reviewed every few years, such as pet rules, architectural review guidelines, parking rules. They should be reviewed every few years to determine whether amendments are necessary. Now, on the subject of operating rules, not the declaration, not the bylaws, but the operating rules, those are not necessarily presumed to be valid. Normally, courts look at those to determine whether they're reasonable. In other words, they don't presume their validity, they don't defer, they don't exercise judicial restraint. They actually look at at whether the rules are reasonable or not. And reasonable, it means almost the same thing it would in a constitutional review context. Does the rule bear some sort of rational relationship to something that the association is entitled to do? Some interest they're entitled to protect. Now, most common subjects of amendments are, first of all, what are called scrivener's errors. And those are drafting errors in the documents themselves. And so these are, this type of an amendment is essentially document driven. In other words, you find a mistake in the document and you have to fix it. And Section 27B of the Condo Act and a parallel provision in the Common Interest Community Association Act covers this type of thing. We're going to talk about that. Another common subject of amendments is adding units to a condominium development. That is only done, typically, that would only be done by the developer. And this is called the add-on condominium section of the Condo Act, and that has to be in the declaration as well. And we discussed this briefly in reviewing the Condo Act. We're going to revisit this again briefly. Restricting pets, restricting ownership of pets, or regulating the activities of pets in the common elements. Very common issue that comes up, especially in condominiums. But it can happen in common interest communities, even in the exurbs. Someone gets a large dog that starts to annoy people. That people have too many dogs. Certain breeds offend people, and that sort of thing. Fences, requirements for fences or bans on fences. These things can all relate to pets. Parking and other changes in the common element allocations. Parking can be done a variety of ways. This sometimes requires document amendments, as if people want to transfer, one unit has 2 spots and only wants 1, or the reverse. A unit has 1 and wants 2. The board often gets involved in these. This can involve deeded parking spots, which means you're looking at having to change the allocations of the common elements. Limited common element parking spots where units each has 2 units, or one has 2 units and another has 1. These are in the limited common elements, so they're allocated to a particular unit. Well, there, by amendment, you might be transferring one of the limited common element parking spots to another unit. This does not change the allocations of the common elements. They're not separately deeded, but in a sense, it doesn't in reality change the percentages of the person's voting interests. If it does, then these things all have to be addressed. So we're going to talk about that. And then sometimes you have just parking spots in the common elements, but they're not limited or restricted to particular units, and the board has jurisdiction over them. So sometimes document amendments are necessary to deal with issues like this. Renting. Very common, probably the single most common amendment issue is dealing with renters. Banning renting, restricting renting, regulating renting. And here the requirements of the GSEs, Fannie Mae, the government-sponsored entities, the Fannie Mae, for example, and the FHA have regulations regarding renting of units, and entire projects become unsuitable for mortgage insurance or for mortgages being purchased and sold into the secondary mortgage market if they have too many renters. And currently, if a development has more than 50% of its units rented, it's going to run into problems with getting approved. So sometimes what drives the ban on renters is the requirements of the GSEs. And another thing you might discover is people want to simply change the name of the project if it has the developer's name on it. If a project was named after Donald Trump, you might find some people wanting to change the name to something that doesn't have Trump in it, or whatever that case may be. Now, the power to amend, we're going to talk about how this all works, but understand that sometimes the power to amend or the decision to amend arises from necessity. It has to be done. Other times, it's a question of the evolution of the project. Amendment needs to be done because of changes that have taken place. So let's speak a bit about necessity. During the period of developer control, The developer may reserve to itself the unilateral power to amend the declaration in order to permit development of the property. We have talked a bit about developer rights, but with specifically here, a really critical one is the Illinois Condominium Property Act, Section 25, that authorizes the developer to, in the declaration, to reserve the right to add on condominium units. So add-on condominium amendments are done pursuant to Section 25, but it has to be done in the, it has to be authorized also in the declaration. But this is a unilateral amendment power, so this is going to be done differently than a normal amendment that happens after turnover of the project to the owners. And the second, to adapt, amending to adapt to changing circumstances. Well, that normal amendment process is described in Illinois Condominium Property Act section, or I'll just say the Condo Act, Section 27A. And all kinds of things can happen here. Why would the circumstances change? Well, one would be that, for example, you may have age issues. It may be that you started off with a project that was intended for young people and it ends up being old people living there, or vice versa. Another thing, you have issues of business purposes, if there are businesses being conducted in the units. And third, necessity to correct errors, scrivener's errors. Illinois Condominium, in the Condo Act Section 27B, which we're going to cover in detail. And then there's this whole question of evolution. And I put this a bit under necessity, but it's also just a matter of how a project may evolve over time. After turnover, the people who live in the communities may want to change the rules because all kinds of circumstances have changed. And one thing that has happened in some developments, it's happened in a number of places in Florida, for example, that where this actually became quite an issue, where there was a lot of housing that was planned for empty nesters, or maybe it was planned for young singles. It was not set up for children. But what happened is, as the housing prices went up, many families with children moved into what were essentially smaller units that were originally intended for people without children. But because larger units and subdivisions that were really adequate for children, that had yards, etc., were simply too expensive. So a lot of people ended up moving into developments that were not age restricted, but that were really not designed for families with children. Well, this causes all kinds of issues because children have a different way of living. Documents have to be amended to accommodate that. So that would be one example, and there are many others as well. You can use your own imagination. The people who live there are different than the ones who are anticipated by the original declaration. This may require documents. So let's talk about how this is done, the procedures for amendment. You want to begin, if you're involved in this, by talking about the whole process and making sure that you understand and the association president or board members you're talking with understand. Make sure everybody understands what you're doing and why you're doing it and whether you want to go forward with it. So one question is this an appropriate subject matter for an amendment in the first place? Now, some issues are going to produce conflict. For example, and I'll touch on this later with a couple of cases, or one in particular, pet restrictions. Boards have authority to restrict ownership and the activities of pets, and really regulating pet owners. That's what they're really doing. But this can be very, very conflictual, and it can produce tremendous turmoil in an association. So you have to think this through. And other types of amendments that may look good may be perceived by people other than board members who may like the idea. It may be seen by others as overly restrictive. Things that pertain to smoking and parties and outdoor activities, obviously pets. These things can just produce conflict. So you have to think that through and whether it's worth doing. Then you have to ask what parties are going to be involved. This requires reading the declaration and looking to see who's going to be a part of the process. Again, it's going to depend on how you do this. Are we amending rules? Are we amending the declaration, the bylaws? And you need to figure out who has to be involved. For example, the board of directors, undoubtedly, they absolutely have to be involved. Some amendments require the owner's involvement, a vote of the owners. Maybe the developer has to be involved. Maybe mortgagees, in other words, banks. There are even some circumstances where a municipality, a local government might have to be involved. Um, and then what about if there are commercial property owners, what about them? So the mortgagee or lender approval uh, may be simple to obtain. If you look at the declaration, if it requires mortgagee approval, then and that means really, looking. This can be complicated, but it may be required. However, it may be the case that you can simply have a default consent provision. In other words, that you simply put them on notice with a letter, and they have 30 days to object, or they are deemed to have consented. Secondly, municipality. Now, this is unusual. Normally, municipalities don't need to consent, but it does happen sometimes. For example, if there are affordable housing requirements, if the developer made an agreement at the time of getting the building permit, made an agreement that pertained to affordable housing and a certain number of affordable housing units, well, it's possible that the document amendment might have to be approved by the municipality. It's just possible. It may just be a formality, but make sure that there isn't something in the declaration about that, particularly if you're talking about amendments that pertain to the number of units, the requirements for architectural modifications, this sort of thing, changing the documents to require that houses be bigger than in the original declaration, this sort of thing. Commercial property owners. Well, the use restrictions on commercial property owners may be different than the restrictions, almost certainly will be different than those of residential property owners. And so if you're talking about amending declaration, you need to make sure that there aren't different types of property owners involved, and ask how it would affect them. Now, this process should always begin after you've figured out what you're going to do and who has to be involved. You then have to look at the declaration, and all declarations contain a provision that will explain the amendment process. In the Condo Act, in condominium property, this is probably going to be standard. It's almost certainly going to track the Condo Act. It's not going to be anything unusual. But in HOAs, especially ones from, say, pre-1990, they may have unique or unusual amendment provisions. And so you have to read them carefully. Sometimes they're really odd, and you wonder why people wrote them that way. Maybe everybody in the development hates the whole idea, but it doesn't matter. You still have to follow it. And one thing you will see is what are called restrictive amendment windows. So the declaration might say that the declaration is only subject to amendment during a 1-year period every 10 years, assuming that it is renewed. Because related to these restrictive windows, you may also find not only is there only a 1-year period every 10 years, but every 10 years the declaration has to be renewed, or else it expires. Or conversely, it may be renewed automatically unless there is a vote to make it expire. So read these old HOA documents carefully. Don't assume they're standard, because often they are not standard, especially in this area, in the Chicago area. There are a lot of unusual, unique ones. And then, after looking at the declaration, understand that the declaration's amendment process also must be compared with and taken in light of the Condominium Property Act, the Condo Act, or the Common Interest Community Association Act. So, the normal amendment process would be governed by Section 27. Now we're talking here about condos. And this is for, again, note, this is for after turnover. The condominium instruments shall be amended as follows. Upon the affirmative vote of 2/3 of those voting. So the default provision is 2/3 of those voting. But that is what you would see. That is the default. But, as it goes on to say, or upon the majority specified by the condominium instruments. So that's why I say step one is look at the condominium instruments. So you'd have 2/3 of those voting in a quorum, or whatever the declaration says, except that no condo instrument can require more than a 3/4 vote of all unit owners. And then it is also, if mortgagee or lien holder of record approval is required, again, it goes on to say that that's a permissible provision as well. So read the declaration and then make sure that it comports with the statute. You can't have a condo declaration that requires more than a 3/4 vote of all unit owners to amend. That's the absolute top. Correction of the scrivener's errors, you see. This is what we're talking about. Correction of scrivener's errors. That process cannot be used if the amendment would materially or adversely affect the property rights of the unit owners unless they consent. So this section goes on to explain that its purpose is to authorize a simple process of amendment requiring lesser votes to correct errors when the property rights of the unit owners are not materially or adversely affected. So there's I think a safeguard here against abusing the scrivener's error procedure and the board sort of running roughshod over people's property rights without a unit owner vote. Now, what if you have an error or omission, what you believe is an error or omission, that can't be corrected by paragraphs 1 and 2 of this section? Well, then the circuit court can hear a petition of unit owners or of the association to correct the error. And so this then can be corrected by judicial action. Now you may ask yourself, well, what is the point of all this? Why do they have all these detailed provisions in correcting scrivener's errors? Because the standard amendment processes in document amendment processes are so burdensome, are so difficult. And so it may be that only the board cares enough about this to fix an error, but there's an error. There's something that really needs to be corrected, and they can't obtain, 2/3 of the people. They can't obtain a quorum. They can't obtain a 2/3 vote. They can't obtain whatever their declaration requires for a standard amendment. And so that is the purpose of this. And maybe they don't technically fit within 27B. So there's a final expedited process here, which is to go to the circuit court. But understand, these are all efforts to get around the fact that the lending industry and government agencies have required supermajority provisions that often are difficult to satisfy. Often it's simply that not enough people want to come out and vote on it at all. Now, in a common interest community, or HOA, remember we're talking about a different act now. Many of the provisions are similar, but understand homeowner associations, common interest communities, if you will, are much more creatures of their own documents, creatures of common law, as we said, than they are creatures of statute. And so there are provisions in the Act about recording these, that modifications or amendments must be recorded, but understand, and they must be executed and recorded by the president, etc. There are special restrictions on restrictions on leasing, which you'll see here in subsection C, protecting grandfathering in existing owners. But and there's also a special provision for incorporating common interest communities as a municipality. That requires a signature of 2/3 of the members of the association. This happens occasionally. But pay very close attention, if you are dealing with an HOA, very close attention to the language of the declaration, because as I said, it can be unusual, and that it will be enforced. I've seen some very strange things happen in courts over these amendment provisions. So now let's talk about some typical restrictions and then some of the major cases. I mentioned this earlier: rental restrictions, pet restrictions, add-on condominium units, and limited common element changes, and sometimes subdivision and combination of units or portions thereof. I've got a few cases on some of these. First, rental restrictions. This is the most common amendment, according to many attorneys who practice in this area will tell you this. Why? Because developers, when they are selling a project, they want to sell every unit they possibly can to anybody who will qualify to buy it, including people who want to rent their unit out. But after turnover, owners frequently want to restrict renting. Now, there can be several reasons for this. One might be lifestyle conflicts, that there are owners and there are renters in the community, and the ambiance of the association is an issue. That the renters behave differently than the owners, and this may especially be the case if people are engaging in relatively short-term rentals, vacation rentals, this sort of thing. This can cause real conflict. There's also sometimes concern about, now first, this is the lifestyle conflict that pertains to the renters themselves, but there's also the other side of it, that is the owners who live in the project don't like the voting situation with respect to the absentee owners. So one part of conflict can involve the renters, the other can involve the owners of the units that are being rented, because their voting behavior may be a problem. They may not have the same interests in voting to approve certain things in the project as the resident owners do. Then I mentioned the requirements of the GSEs. That may also drive a ban on renters, and a concern that there are just simply too many. And so one type of restriction would be banning all renters, another or all short-term renters, or another would be all non-family renters, another would be above a certain percentage you can't get permission to rent at all. And so you have percentage restrictions, etc., and hardship exceptions and exceptions for family members. So all these things, other things that have to be discussed, and this type of restriction is very, very common. Another one is pet restrictions. These are usually done by board rule. Now, the authority of boards of directors to restrict pet ownership by board rule is clear in the law. If there are provisions in the declaration, though, then you better read those very carefully, because the board, if there are provisions in the declaration or the bylaws, those would limit the board's authority. They can't do anything that is contrary to their own governing documents. But this is a very emotional issue, and boards are very well advised to proceed carefully, especially with consideration for those who already have pets, because for most pet owners, their pets are like family members. And also keep in mind that so-called pet regulations or pet restrictions are really pet owner regulations. Always keep in mind, you're not regulating the pets, you're regulating the owners. And that is exactly how they perceive it, and this always causes problems for people who believe that their dogs are actually human, their cats are actually human beings. Cases have been known to go all the way to their state Supreme Court over pets. One famous case in California is called the Narstedt case, N-A-H-R-S-T-E-D-T, Narstedt. And this woman, Mrs. Narstedt, took her case involving two cats all the way to the California Supreme Court. And they made major case law over, how to evaluate association rules. What was it over? Two cats. So tread carefully here. That's, I think, probably pretty good advice. So now we're going to go through some of the leading cases on document amendments. I'll state them quickly here, and then we're going to go through each one in detail. Hidden Harbor Estates versus Basso. This is the only out-of-state case I put in here. The rest of them are all Illinois cases. But this is a very famous case, 1981. It is cited all the time, all over the country. And Illinois courts and the courts of other states cite it with regard to the nature of association rules, and there being two different types of rules that we're going to address this. Very important case. Next, Crest Builders versus Willow Falls Improvement Association. This has to do with the board of directors making amendments to take away developer rights. The Apple II Condo Association case, we just call it Apple II, restricting rental of units by document amendment. Important case, and important to understand that certain portions of it that have been viewed historically as law are now being viewed as dicta. And when we get to the Stobe case on the bottom, you'll see what I mean. Another major case, the Hinojosa case, Board of Directors of 175 East Delaware Place, which, if I'm not mistaken, is the John Hancock building, versus Hinojosa. We just call it Hinojosa. So you've got Apple II and Hinojosa. This involves, yes, restricting pet ownership. Stowe versus Lolita, very important case on developer changes to the common elements. Picerno versus 1400 Museum Park Condo Association, which has to do with changes to the common elements and the power of owners and courts to bring about such changes. And then, as I said, Stowe, that case just from 2016, Stowe versus 848 West Bradley Place. This involves a board rule change regarding renting of units, which revisited the issue you found in Apple II. The Apple II court, there's some dicta in that opinion that talks about banning renting by board rule, and the Stobe case takes up that exact issue, but not as dicta. So you'll see how the law has changed on this. That they made here. They said that you have Category 1, Category 2. Category 1 is original rules found in the Declaration. Category 2 is board-adopted rules and discretionary decisions by the board. Category 1, presumed valid. Category 2, they have to be reasonable. Now let's look at Crest Builders versus Willow Falls. This is an Illinois case, 1979. What happened here was after turnover, the HOA board and owners approved amendments to the documents that would remove the developer's rights to advertise and maintain model units on the property. Now this is in the declaration, but nowhere in the declaration did it say that the board could not amend the documents to do this. So the developer sued to enjoin recording of the amendments, and there's a complicated procedural issue which we don't need to worry about, but the court ultimately said, look, in drafting the declaration, remember how you normally construe documents against the drafter. In drafting the declaration, Crest could have precluded amendment to those provisions. Or it could have given itself a veto power over changes to the developer rights. But they didn't. And so the board can go ahead and amend the documents. As long as they follow the procedure, they can amend the documents to remove the developer's rights. So if you're advising developers, keep this in mind. If you're drawing up original documents at some point in your career, make the developer's rights provisions unamendable by anybody except the developer, or at least include a developer veto over that amendment. It'll be enforced. Next, Apple II. This is about rental of units. So again, you want to pay attention to this one and also to the Stobe case. The court rules, this is back in 1995, that condo associations can legally restrict the rental of units. Now this is where you get the dicta, the law and the dicta. A leasing prohibition may be done by either an amendment to the declaration and bylaws, and I put in here, as it was in this case, or it could be done by rules and regulations. And this is what was not done in the Apple II case. The court simply said another way they could have done this was by amending the rules and regulations, in other words, by board rule. But that's not what happened. In this case, it was done by an amendment to the declaration. And the court says an amendment to the governing documents is presumed to be valid because it represents the vote of a supermajority of the owners and it's part of the recorded covenant, so it's binding on the unit owners who purchase subsequently. But it's also binding on those who purchased their condos before the amendment. Why? Because condo owners are charged legally with knowing that the declaration is subject to amendment. Condo owners do not have vested rights in the status quo, again, unless they're specifically exempted. So, as I mentioned, the developer. I mean, the developer can exempt him or herself from subsequent amendments, but the ordinary unit owner is not going to be in that position. So this is an important case for a number of reasons. But understand the loophole here. the part about using the rules and regulations to ban renting, that was dicta, because that's not what happened in Apple II. And as you'll see, we're going to come up on this again. The Hinojosa case. In this case, the board adopted, this is not an amendment of the deck. It is not an amendment of bylaws. The board adopted a rule, and the rule barred owners from bringing additional dogs onto the premises. The deck and the bylaws said nothing about pet ownership. Now, for that reason, there's no conflict. See, that the board can't make rules that conflict with their own declaration. But there's nothing in the declaration about pet ownership. Therefore, it was within the power of the board to do this. The rule was promulgated by the board, and therefore, pursuant to the Hidden Harbor case, it is not clothed with a strong presumption of validity. But when you look at it, is it reasonable or not? You scrutinize the rule to determine if it's reasonable in purpose and application. And the board explained why they had this rule, that it was to prevent possible injury or harm in the common areas. And because the board applied it to everybody, and the purpose was rational, the rule was reasonable under the facts of the case. So, the point being here, and the board, in this case, the court cites various cases in support of its ruling, that pet rules are ordinarily reasonable because, especially in urban condos, this is a real issue. Dogs, people can get hurt, they can get attacked, dogs can fight with each other, they can be unclean, etc. And so normally, it's perfectly okay for boards to regulate rules. You just make sure when you make a rule, as the board of directors, that you state why you're doing it. It's best to put all these things in writing. That is, to have, when the board adopts a rule, to make some findings, to state why you're doing it, to make it easy to defend. Stu versus Lolita, 1981 case. This is an interesting case. The developer made a mistake. They made a commitment to a couple who were buying a house that they were going to have 2 parking spaces in the common elements. And then what happened was they did not have enough parking spaces where they said they would be in the building. And so it's just the way it worked out. And so they said, well, we'll just create a new parking space. So the developer created an additional parking space in the common elements, but he never amended the documents to do it. And so what essentially happened here was the defendants in this case, the people who bought, who were promised the extra parking spot, were essentially trying to purchase or lease from the developer a parking space which the developer did not own and did not have the right to control. And the declaration said that changing percentages of the common elements required 100% vote of all the owners for a recorded amendment. Well, the developer, of course, didn't do that. And when they did attempt an amendment, they didn't have 100% vote of the owners. And so the attempted amendment was ineffective. And so the disputed parking area that the developer tried to give to this couple was still part of the common elements of the condominium. So this is a case involving essentially limitations in what the developer can do. Allocating common element to people, element spaces to people, changing the percentage interest in the common elements, these are matters that require document amendments. Paserno, this is kind of related, this Paserno case, 2011. So here we had 2 family members, 2 sets of family members, who owned adjacent units, and they wanted to build a door that would connect their units. And the association looked this over and decided this would require a document amendment, because they said it would require converting several feet of the common element hall space into limited common elements that would be appurtenant to one or the other of these 2 units. Because the way they wanted to build this door, it actually required using a disputed amount of the hall. It's either 32 square feet or 64 square feet, depending upon who you agree with. Well, the Paserno said, well, that part of the hall, nobody uses it anyway. Nobody needs it. But and so when they went to the trial court agreed with Paserno, and what they did was essentially they partitioned the common elements. They said, this little portion of the common elements. But the appellate court said, no, you can't do that. This is contrary to Section 4E of the Act, the Condo Act, which expressly provides that once the percentage of ownership interest in the common elements has been determined, that percentage remains constant absent an agreement by all unit owners. So as in the previous case, you see, when you're starting to mess around with reallocating portions of the common elements, you're changing the percentage interest of the condominium. And so even the trial court can't do this. This is not a scrivener's error. This is physical property that the Pasernos wanted to change the nature of the common elements. And even though you could view it as de minimis because people could still use the hall, it's common element space and it requires that you follow the procedures of the governing documents. And now we come to the Stobe case. This is a recent case. This is 2016. Now this is, again, this involves renting of units. The declaration did not expressly permit leasing of units, but it did say, no unit shall be leased or subleased for hotel or transient purposes for terms less than 6 months. So there's a provision there that says you basically no short-term leasing. The board then adopted a rule, and this is a rule that provided that no more than 30% of the units could be leased at any one time. So there's a provision that prohibits short-term leasing, and then a board rule that puts a cap of 30% on all units leased for any amount of time. So the unit owner says the rule conflicts with the declaration. Now, of course, as you can imagine, the board is citing the Hinojosa case and saying, well, it says in the Hinojosa case that the board of directors can restrict renting by board rule. But the appellate court says, because the declaration has spoken on the matter of leasing, because there actually is a provision in the declaration that covers leasing and bans short-term leasing, any augmentation or diminution of an owner's right to lease the unit must be accomplished through an amendment to the declaration, not a rule promulgated by the board. So because there was a provision in the dec that spoke on leasing, the board can't go beyond it. The board can't, that matter is addressed in the dec. If there hadn't been anything, then you have a different story, but there was. Well, what about the Hinojosa case that says in dicta that it's perfectly okay for boards to do this? Well, the court distinguished Hinojosa because in that case, there was no declaration provision on the subject. And also, again, they point out that we're not talking about the ruling of the case, so they don't have to overrule Hinojosa. It was just dicta. So this requires looking at the declaration, doesn't it? And making sure that there's nothing in there on leasing. Because if there is, then you're going to have to ban leasing by document amendment. And personally, I and many other people who have talked about this over the years have always thought that what you find in Hinojosa about boards banning renting was really questionable. That many people have thought, it should require a vote of the ownership. It should require a document amendment. It seems like quite an extension of the power of boards to say they can do this. I mean, banning pets is one thing, but when people buy a unit in a condominium building, often they and it says in the dec, or there's nothing in the dec that prohibits renting. People assume they can rent their unit, and so when it's one thing if the owners, 2/3 of the owners, come in and decide to prohibit renting. That's one thing. That's the vast majority. It's a supermajority vote. But where the board, 3 out of 5 board members or something like that, decide to ban renting, that is really stripping away something that may be very important to a number of owners. So you can see why the court in Stowe addressed it the way they did, I think. So let's wrap this up. Document amendment is a common task for community associations and their attorneys. It may become necessary for a whole variety of reasons. The as we talked about, it may be a necessity. It may be changes in the project, changes in the lifestyle. But always remember the procedures have to be followed carefully. Always begin with the amendment section of the declaration in question and or the bylaws. Read the statute, Condo or Common Interest Community Association Act. Be aware of some of these major cases, and always remember you have to follow the formalities. Make sure that it's amazing how often people don't. Make sure that it is recorded. Make sure it is signed by the president or the authorized officer, etc. Make sure the formalities are followed. And you have in this section a number of amendment documents that you can review to see as samples to see how this is done. And then also, just as a cautionary provision, always keep in mind that amendments to documents produce controversy. Amendments, that means change. And change threatens people. Psychologists tell us that when people feel they're going to lose something they already have, it produces intense feelings of anger and resentment and fear and so forth. Change, and particularly change involving loss, produces strong emotions. And you always have to keep that in mind in deciding whether you really want to proceed with an amendment. If it's about banning smoking in some portion of the common elements, or restricting pets or flags or anything of this sort, Christmas displays, holiday display, etc. Be careful about this to avoid producing controversy, because it's an astonishing fact, but it's true. People will often go to court and spend tens of thousands of dollars in attorney's fees over matters like this that may seem symbolic. You may think they wouldn't do it, but actually sometimes it happens. So there you have it, and that concludes our session on amendments. Take a look at the materials. Most of these cases are there in your folder in full. There are also summaries of the cases and summaries of some of the key sections of the Condo Act and the Common Interest Community Association Act, and some sample documents for your review, a checklist, etc.